Welcome back, everyone, to Open Line. Tim Takacs is with us talking elder care law, and several calls. Great opportunity to call in, get your questions answered about your situation. I'm going to go to Renee and then Wilma. Okay, so hold on the line, Wilma. But Renee, what's on your mind?
I plan on leaving my state to my daughter. Now, she's not married. What if she decides to marry and something happens to her? Can her husband inherit the home?
Yes. Now, let me just say, let me preface that by saying that, okay, so Wilma, right? So if you've died already and you leave your house to your daughter, then she can do with it what she wants. So, but if she marries while you're still alive, then and then you pass away and you leave her the house, needless to say, the house is hers and she can still do with it what she wants. I've seen cases where the family farm has gotten out of the family because at the death of somebody in the family, it wound up going outside. It wound up outside the family. That asset. So I don't know if that answers your question, but that's like the short version.
Short version, though, the answer is yes. You give it to your daughter. Your daughter marries. It would then go to her husband.
Right, if she chooses to leave it to him. If
the daughter chooses to leave it. And I guess right. I'll just add, I don't know if this is what Renee wanted at all, but I mean, could Renee give it to her daughter and for some reason say, I don't want it to ever go to her husband? That would be crazy, wouldn't it? But could you do that?
No.
No, you just couldn't even do that.
Not that I know of. But basically what you're talking about there, and those are cases where you might, you may be thinking about using a trust. Mm-hmm. So that essentially you have a trustee that controls what happens to that asset.
Now, Renee might still be. Does that answer your question, Renee?
Yeah, because, okay, right now she's not married. She has children. And I want to leave the property to my daughter and her kids. But right. I don't want her to marry after I pass and then something happens to her and the husband gets it. And she's not married at the time. But if something was to happen to her, I want the house to go to her children, not her husband.
Yeah, your grandchildren. Yeah, right. And that's one of those things where, stuff like that happens, and those kind of issues come up all the time for us, where, that's maybe the most valuable thing that you can leave for your daughter. I mean, obviously financially, and you want to make sure that your grandchildren get it, ultimately, because it's both. Now you can, like I said, is maybe you have a trust in place so that, that your daughter and her children, have the right to live in the house or occupy the house, maybe even rent free or whatever, so that your daughter can't, so she can't give it to her husband or bequeath it to her husband or somebody else.
Boy, that's that's very interesting. Renee, I'm glad you called with that question. That's very interesting. It sounds like it's not easy what you're trying to do, but that's very interesting. All right, I'm going to go to Wilma now.
Yeah, it really isn't easy. Yeah.
Yeah. Wilma, hello.
Hey, y'all.
Hey.
Well, Mr. Hall, buckle up.
All right, good.
Mr. Takacs, yes. I met you first back in 2008, and I'm getting ready to ask you some questions, and I'm serious about this, and you were respectful to me back then, and I don't mean to be disrespectful, but if you don't feel like you could answer or feel like answering, that's your prerogative. Your last caller brought up an interesting point. The way I understand, I've been an administrator of an estate before, and I had a very difficult error in the estate that I had to deal with. But, I try to follow the rule of law by definition, what things meant, according to the spillover will and everything, and it was a trust. So I'm just wondering, by the definition, when you say spouse in the state of Tennessee, that is defined by the state of Tennessee, and is that correct? I'm not finished, but is that correct, that term spouse is defined by the state?
Yes. Yes, it is.
He said yes.
Oh, he did? Okay,
Yeah.
I can't hear him. So, all right. So let me ask you this. With the recent Supreme Court ruling on abortion and the briefs that were presented, one in particular by Clarence Thomas, talking about overturning gay marriage, a lot of gay people were so welcoming to have the legal protections under the term of quote-unquote marriage, okay? Because in the past, a lot of them that had, some couples that had been together 30, 40 years, whenever one of them died, the other's family came in and just took total possession of the property and might have displaced a senior citizen out on the street with no protections whatsoever. So what I'm wondering, say they overturned gay marriage and the term spouse cannot be used for a gay person or a homosexual person, I guess I'm trying to use the right word. I've been told here lately, a queer person, they can't use the term spouse, okay, because by definition of law, that may not be legal anymore. So if they set up not just a will, but a trust, which you say is a contract, what are the odds that, say the surviving or the dead spouses or dead partners' family could come in and overturn the terms in that contract, that trust, and just take away everything again from the surviving partner in that relationship?
Okay.
Have I made myself clear?
Yeah.
Yeah.
All right, thank you.
I'm going to hang up and listen because I
clear on
can't
that.
hear him responding, Mr. Hall.
All right, thank you, Wilma. Thank you. All right, go right ahead.
Yeah. Wilma is exactly correct, is that, in the past, that's, when I think about it is, that's, of course we do elder law here. So, we're not, we weren't seeing, 75-year-old, same-sex couples coming to us wanting to get married. At least I don't recall any recently. But that's what would happen is that they would establish a contract, which essentially would be, as far as the disposition of their estate, would be, they would be setting up a trust, and the trust would make provisions for, that, okay, I'm spouse one, and I want to make sure that if I predecease spouse two, or I'll call spouse two, but partner one and partner two, say, then we set up essentially a contract that provides that my assets will make sure to be used. We'll go to partner two. That's essentially how that would work. So in effect, that's like sort of a surrogate or a substitute or a replacement for, a marriage contract. Because when you think about it, marriage is a contract. But that is something that, that marriage, when you get married, spouses have unique rights that, like life partners who are not married do not have. So essentially what has to happen is that, say, those life partners, they have to develop a contract between themselves, that essentially emulates or simulates, what those rights or essentially the rights that married people can enjoy. That's really what we would be doing in a case like that.
Very interesting question. All right, Wilma, thank you. Thank you. She said buckle up, and then she came with that question. I appreciate it. All right, we'll take a break. We'll come back, continue our discussion. There's a number if you want to call in, 615-737-PLUS, 615-737-7587. We'll take a break. We'll be back right after this.